Hear ye, hear ye. Court of Appeals for the First District of Texas is now in session. Pursuant to authority of God save the Constitution and this honorable court. Please be seated. Welcome to the First Court of Appeals on a blustery January afternoon. Luckily, everything city isn't shut down today, so everybody's able to make it. We have one cause on the docket today, case number 0123-00443-CV, Kinetic Connect LLC versus Tran Dang. And could I have the appearance of counsel? Ms. Langler?
Karen Landinger for Kinetic Content Agency.
Gretchen Swag for Tran Dang.
Thank you. And you have 15 minutes total. You can reserve time for rebuttal.
I'd like to reserve 5 minutes.
You may proceed.
The Texas Citizen Participation Act was enacted for the purpose of protecting certain vital constitutional rights. Key among those rights is the right to petition the court for relief. It is undisputed that when Kinetic Content filed a special appearance, it was exercising its right to petition the court. The issue in this case is whether the protections of the TCPA can be evaded through creative pleading. Kinetic Content asks this court to find that its actions in applying for a special appearance were protected for 3 primary reasons. First, the TCPA is to be afforded a plain language interpretation. Under the plain language of the Act, a motion for sanctions is in fact a legal action. Number 2, the Texas
Sorry,
Supreme...
can I stop you there? Can you explain that statement that you just made?
About...
That a motion for sanctions is a legal action. Can you explain?
Sure, absolutely. The definition of a legal action means, and it's very broad, it means lawsuit, cause of action, petition, complaint, cross-claim, counterclaim, or, and this has been the hang-up, any other judicial pleading or filing that requests legal, declaratory, or equitable relief. Now, I understand that recently some courts have looked at the exception to the Act, and the exception that the legislature crafted said it was excluding filings or motions that do not add a claim for legal, equitable, or declaratory relief. And I think the most insightful answer to why a motion for sanctions adds a claim is actually came from the 14th Court of Appeals, which I know is not controlling on this court, but I like the way it was worded. That's McAllister versus Samuels. And in that case, the 14th Court of Appeals stated that a claim for frivolous sanction damages is a claim for affirmative relief because it is dependent on new facts and evidence. That explanation sounds a lot like Montelongo versus Abreu. And of course, in that case, the Texas Supreme Court was looking at a different issue, but undertook to determine whether or not an amended pleading added a new claim. And the court instructed when we're undertaking that analysis, what we look at is to see whether or not new facts, new issues, new evidence is being brought to the court. So a motion for Rule 13 sanctions, in this court, in Descendant Corp said a motion for Rule 13 sanctions cannot be based on the merits of a claim, right? So if a Rule 13 motion for sanctions can't involve the merits, what's already before the court, it necessarily has to involve something other than what's already pending before the court.
But isn't looking at the purposes of Rule 13 itself? I mean, these are the same 2 parties. There's a procedural right under the procedure under Rule 13 for groundless pleadings, it's hard for me to see a Rule 13 motion, what it's intended to protect, which is groundless pleadings, and a TCPA motion over here, which is to protect protected constitutional rights. Why the use of a Rule 13 motion necessarily implicates that when it's a right given under the code to make a claim that pleadings are groundless for the court to decide. They seem like apple and oranges to me of what the purposes of those two provisions are of Rule 13 and the TCPA.
I would suggest that they can be read in harmony for this reason. Sanctions abuse. We have all, as a defense attorney, we've been flooded with claims. I just had a motion for sanctions filed on me for the act of filing a motion for summary judgment. Those motions are clogging up the courts and causing problems too. So when we're looking at the purpose of the act, and remember in Montolongo, the court said that the purpose of the act is to protect the right, among other things, but to petition the court.
Was that a Rule 13 sanctions claim?
In Montolongo?
Montolongo, and I was going to ask the same question about the 14th court club case. Were those
The
Rule
14th
13s?
court, that was McAllister Samuels. That was a frivolous lawsuit, damages claim. Yeah. And so if we look to the purpose of the act, and the purpose is to be protective, and if motions for sanctions are being abused, is it so bad to say if you are going to bring a claim for sanctions, if you're going to offensively use a motion for sanctions, which requires a myriad of things, including counsel having to go back to the client, have an additional hearing, put on evidence, is it so bad to say if you're going to use these motions for sanctions offensively, that you at least have to make out a prima facie case?
Can't they put that in Rule 13?
They could, but by including it in the TCPA, it covers not only motions, Rule 13 motions, but it covers other proceedings also. And that's something that's important is when you interpret the act according to its purpose, I think it's helpful to think about not what a motion is titled, but what a motion does. Right, and I think Hawkshurst, the Austin Court of Appeals in Hawkshurst, they got this, right? They were looking at whether a slap at a frivolous, allegedly frivolous pleading, whether or not it was subject to the TCPA, and the parties were arguing about whether or not the motion was brought as a motion for sanctions or as a counterclaim. And the court said, no, it doesn't matter how you're bringing the motion. It doesn't matter what title you're giving to it. What matters is what the motion does. And if you're filing a frivolous pleadings motion, you're asking for a legal and equitable relief. So instead of getting caught up on these hyper-technical titles, go back to Montolongo and say, what is the purpose of the act? And what are these motions doing despite how they're being titled?
May I
Sure.
ask a question here about, you mentioned, bringing in new evidence, which is what the Montolongo case sort of focused on with an amended pleading, right? And so here, and I agree that it doesn't matter that we call it a motion for sanctions or what the title of the document is. What we're talking about, though, is we're not talking about, are we talking about evidence in the sense that the evidence is the litigation conduct itself, right? It's not talking about evidence that is supporting a new cause of action or a new claim.
In this case, what it was alleged is that a non-party committed perjury, basically, by filing a false evidence, attaching false evidence to a special appearance. That had nothing to do with the underlying claims in this case. That involves whether or not an executive for Kinetic was lying. That's a completely different set of operative facts. Those weren't already, in fact, that was even admitted in the briefing. This involves something that wasn't already before the court. And I think that that's where we need to distinguish motion for sanctions from some of these other motions that courts have been concerned about. When we look at something like, let's say a Rule 91A motion, or even an anti-SLAPP motion or a motion for summary judgment, what you're asking to do is you're asking the court to take something that's already in front of it, to take, here, this is already in front of you, please rule on this, please dispose of this. But the same cannot be said for a motion for sanctions, because a motion for sanctions, as this court has recognized, cannot be merits-based. It is not, it's improper to bring a motion for sanctions based on the allegation that the claim is improper. What you have to show is that it was brought for an improper purpose, and in this case, that somebody lied, committed perjury. That's a completely different set of facts. And I would suggest that under Montelongo, which described what constitutes a new claim as the addition of new facts, that falls within the definition.
So, quote the definition under subsection 6, but you did not delve into the exception immediately below it. So the term does not include a procedural action, right? So Rule 13 falls under that. Procedural action taken or motion made in an action, so we already have an action for the lawsuit, that does not amend or add a claim for legal, equitable, or declaratory relief. How is a motion for sanctions a claim, and how does that relate to the claim made in the original lawsuit?
Again, the lawsuit, well, actually the lawsuit was based on, had completely different facts. The issue was a special appearance, right? What Connecticut filed was a special appearance. It was asking the court to determine its own jurisdiction to hear a case. What was alleged is not, and here's part of the problem, and this is part of the problem with just saying, hey, we're going to exclude all motion for sanctions, because you can title a document anything. In this case, plaintiffs brought an attack on the special appearance based in large part just on the merits of the special appearance itself. That's a flat-out attack. I agree. That part wouldn't necessarily involve a new claim. So I agree with that. But in addition to that, they said that one of the affiants lied. They also
How is that a claim?
Because they're seeking relief, they're seeking monetary damages. And this was interesting. If you look at the billing records that supported their request for monetary relief, they asked for over $18,000 for things such as researching the special appearance, responding to the special appearance. There's no fee shifting in special appearance. They're asking for additional monetary relief for having to come in and just respond to a merits-based response. So that's one, is that there's this request for monetary sanctions that they wouldn't otherwise be entitled to. And number two, it's not enough just to prove we were wrong. Motion for sanctions are not appropriate based on the proof that we're wrong. If I was wrong, I was wrong. It has to be based on evidence that it was brought for an improper purpose, that was brought in bad faith. In this case, that somebody lied. That's different evidence. That's not the same as just saying you're wrong. And so I would argue that a motion for sanctions, while the legislature did a great job of cutting out some of the abuse that was happening with some of these, I'm going to slap you, you're going to slap me back, that language cuts out those motions because nothing new is being put before the court. But a motion for sanctions involves new facts. And again, I'll go back to McAllister. I think that was a great discussion of it. But also to this court's own point in Descendant Corp. that said a motion for sanctions can't be based on the merits of a claim.
What if you had a motion to compel discovery? That there's one party refuses to produce documents, the other party does a motion to compel. It's a motion to compel, so that's asking for legal relief to production of the documents. But it doesn't add a claim for relief. Now, would a motion to compel, under your definition, be subject to, because it's asking that it requests legal, declaratory, or equitable relief?
So
would that be subject to the anti-SLAPP statute?
No, it probably would not.
Because of subsection A, because it does not amend or add a claim for legal equitable relief, right? But it is asking for relief.
I would suggest it
Production
might be
of
based,
documents.
it might be excluded from the TCPA for another reason. And that is what some courts have picked up on, is the fact that, again, you know, these bright line rules are dangerous. What you have to look at is what the motion is actually doing. So if you remember the Best v. Harper case, where the Texas Supreme Court said, nobody is fooled by what you're filing. You're not filing, you know. There was an issue to remove somebody who wanted to run for office. More recently, in Furchichi, a party filed a claim. It was discovery sanctions. You know, they said, hey, you know, you didn't file discovery, or you didn't produce discovery. And the court said, that's not what, really the basis of your attack is not really what you're attacking. What you're really attacking is some communications that happened in a mediation. And so in those courts, you can see that the definition or the application of the TCPA is further narrowed by its purpose, which is to protect certain rights. Discovery abuse would not be a protected right. So that would automatically be excluded from the Act. But that's
So what is the protected right here?
the right, well, the right to file a special appearance. And if we had come in and filed a false and fraudulent affidavit, I guarantee I wouldn't be standing here today, but if we came in and filed a false affidavit, and the claim was, you filed a false affidavit, you're out, then no, I would say the TCPA would not apply, because that would not be a protected right. But coming in and saying, well, we're gonna file sanctions against you. We're gonna ask for all of our money for having to respond to the motion because we disagree.
Right, so what you're saying is that in a correct motion for sanctions because one party files a fraudulent affidavit, is not protected under the TCPA, but an incorrect motion for sanctions is protected under the TCPA.
I'd say more that the analysis is less on, should be more focused on the purpose of the Act, which is to protect a party's right to petition the court, and that it would be excluded because a party does not have a right to file.
Right, but what does it mean to petition the court? I mean, you're defending, it seems like the underlying plaintiff is the one petitioning the court for relief, and you're defending that.
No, filing a special appearance is petitioning the court for relief. We're asking the court to consider its own jurisdiction. And it would be a dispositive motion also.
I guess what I'm struggling with is that if the TCPA is sort of a threshold showing that certain types of pleadings just should not, or actions should not be permitted at all. But what you're saying that the court then has to do a qualitative analysis and look at the opposition, and look at the motion for sanctions. And if it's correct, then that, you know, there was a fraudulent affidavit attached, then that's not protected by the TCPA. But if it is incorrect, then it is. So how do we draw a line without going into a substantive analysis of whether the motion for sanctions was correct, which in turn depends on whether the special appearance was correct?
I think the easy answer to that is back to what I was saying. In light of the offensive use of sanctions, why not let the TCPA apply? And then you have your three-step burden shifting analysis. If there is a prima facie case, fine. There's nothing in the TCPA that says you can't bring sanctions. You can bring them. But if you're going to do that to a party, at least be able to articulate a prima facie case. And I would suggest that perhaps the legislature considered that. When it drafted the 2019 amendments, it was fully aware of all the cases out there and the calls to narrow the definition of a legal action, and it didn't. It gave us the exact same definition of a legal action. It gave us some exceptions, but it did not exclude a motion for sanctions from the definition of a legal action. And maybe the court did that because sanctions should mean what they say. A sanction should be a sanction. It should not be a merit-based attack.
Could you have filed a Rule 13 to her Rule 13? That was a frivolous motion. Sounds kind of silly, but that's kind of what we're talking about. She's filed a pleading, she's filed a motion. Why do we have to jump into the TCPA and just look at it under Rule 13? You could say her motion is frivolous. For the same reasons you're giving us, the trial court would have that same authority to weigh. I mean, I've never seen that done, and I almost feel silly asking this question, but you know, that kind of is in line with what we're talking about. You filed a frivolous, so she filed one, and you filed one, and then let the trial court make those kind of determinations instead of jumping into a TCPA three-part analysis for constitutional issues. I mean, I don't know. I've never seen that.
But I think the TCPA, I know we're just talking about the right to petition, but it was broad. It had this overarching theme of being protective in nature. And so why not exclude, instead of parsing out and revising all of these, instead of revising Rule 13 and revising all these other rules, why not create this umbrella that encompasses this to prevent some of the abuses that were happening? I think it was wisely drafted.
Any further questions?
No.
I have gone way over my time. Thank you.
Thank you. Ms. Sween will get 9 minutes extra should she elect to use it.
Thank you, Your Honor. May it please the court. I think I'd like to start where we left off. We were discussing ultimately the purpose of filing the TCPA motion in this case. If you do a little thought experiment, think about what would have happened had that motion been granted. Nothing, no claim would have been eliminated from the underlying tort action. All that would have happened would be our request for sanctions would have been denied, which is what happened, and that has not been appealed, though we feel we did more than establish a prima facie case that sanctions were warranted. And I will note here, because we may not have time for this, that because of the mess created in, particularly in the Third Court of Appeals about whether or not a sanctions motion can be susceptible to a TCPA motion, they themselves are backing away a little. And in Clear Diamond, the panel very smartly said, we're just going to assume without deciding that a motion for sanctions is susceptible to a TCPA motion. And then they looked at the request for sanctions and what had been filed in support of that request. And they said the non-movement more than satisfied the prima facie case burden, we're done. Your Honors, you could do that here. We adduced overwhelming evidence that they had filed a frivolous special appearance. There is no legitimate argument that they were prevented from filing a special appearance. But there's no right to file a frivolous special appearance. And indeed, the rules that govern special appearances themselves, Rule 120A, expressly encourage the court to consider at any time if something has been filed in bad faith, if there's no basis in law or fact, or if the supporting affidavit is reflecting bad faith, sanctions are warranted.
All right, I'm going to jump in here.
Yes.
So sort of piggybacking on the concept that it doesn't matter what the filing is titled, if we just look at the, and I'm going to use this term sort of loosely, relief that is being requested, if we're saying that, and kind of taking the appellant's thought to a further place, that if it wasn't just about sanctions for, filing, the special appearance, that you're also saying that their client lied, and you asserted a fraud claim against them based on that. Would that be subject to a TCPA motion?
And Your Honor, we did not do that.
I understand that. That's why I said
Yes.
I'm taking this to a further place than where it was introduced, to say if that's what you had done, if you had said they've committed fraud, they were trying to deceive the court by filing this
Right.
fraudulent affidavit, would that be subject to the TCPA?
Your Honor, I believe it would, because words matter, and we start with the plain language of the statute. And Justice Kelly was reading this earlier, that the amendment makes clear that a motion made that amends or adds a claim for legal, declaratory, or equitable relief is not excluded.
Right, so can you
But we made
explain
no
why?
claim. We brought a request for sanctions, which we had no affirmative right to.
Right. So what I'm saying is so that you can, and I'm trying to help you explain this.
Yes.
So that I'm sort of giving you the question so that you can then explain why what you did was not an affirmative claim of fraud, where you were seeking damages for their alleged fraud.
Exactly, Your Honor, because legal relief is a term of art, and it means that you are seeking damages based on a claim recognized at law. There is no claim for sanctions as there would be for a claim for common law fraud. And one problem with the reply brief that appellants filed is they conflate all of these sanctions cases. For instance, if there is a statutory right, for instance, in a breach of contract case, to seek attorney's fees because you won, that is, and somebody non-suits the case, that affirmative right to attorney's fees, which is in some sense a sanction because it's a fee-shifting mechanism, well, that, the Supreme Court has said, will survive a non-suit. It's an affirmative claim. It's ripened. That is different from asking a court to exercise its inherent authority to sanction litigants and parties for bad behavior in the course of litigation. So,
did you or did you not, in your motion for sanctions, accuse the appellant of filing basically a false affidavit?
Your Honor, we didn't use those words, and we didn't even file a motion. We added to our response in opposition to the special appearance, which, by the way, we included as Exhibit 2 to the hearing exhibits, just so you could see. It's a request for sanctions made at the end of the pleading. And, of course, if you're going to accuse someone of filing a pleading in bad faith, you need to adduce evidence to support that. But our evidence was the response to the special appearance. You know, it's ironic that on one hand they've suggested we brought no new evidence beyond our opposition to the special appearance to support the request for sanctions, and then today you're arguing, oh, we brought new evidence, therefore it amounts to a claim for affirmative relief. We had to bring evidence to support the request for sanctions, which we have no legal right to. We don't have a right to attorney's fees. It is a discretionary matter for the court. We feel that we more than proved that there was no way any legitimate lawyer could have filed this special appearance in good faith, that the whole point was to come up with a basis for an interlocutory appeal. And they managed to come up with not one, not two, but 3 bases and one tiny tort action to stop everything, shut down discovery, and proliferate the litigation so that here we are a year later, we still have no discovery, everything's shut down, and you've got 3 appeals in this one tiny case that you're dealing with, Your Honor. But this, I want to read from the Third Court of Appeals, their most recent decision on this whole question of is a request for sanctions susceptible to the TCPA. This is the Pate versus Haven at Thorpe Lane case that was decided in October 2023. This is at page 6 of it hasn't yet been published, it's been designated. But this is what they say about Rule 13 sanctions, which is what we requested. We believe the Thiessen Court, which is out of Beaumont, the Thiessen Court may have reached the correct result because a Rule 13 or Chapter 10 challenge to an existing pleading as being frivolous adds neither new parties nor new essential factual allegations. Thus, the idea that such a challenge by itself adds a new claim may be illusory, even if it includes a request for sanctions. So even the jurisdiction that produced Hawkhorse, which is a decidedly problematic opinion that they've invoked here. And I want to talk about that, if I may, what's wrong with that decision. But it's factually distinguishable from this case, because Hawkhorse, what the non-movement did was file a counterclaim that was saying the entire lawsuit was frivolous, and then wanted some sanctions. Right? And then along comes the TCPA motion, and Hawkhorse said, well, you're seeking money, that $5,000, so it's a claim for legal relief. But Justice Pemberton, dissenting, was like, no, that's not what legal relief is. Legal relief is tethered to a cause of action. It's not just, I want money because you behaved badly. It's that there is a claim the law recognizes and I'm entitled to monetary damages. Now, the other jurisdiction they invoked was the Fourth Court of Appeals, where there have been two cases where the prevailing parties were represented by these same lawyers. KB Homes and Whataburger, which they were referring to as Frichichi. This is the other party's name. In those cases, which respectfully, the Court of Appeals in those cases was sloppy with their use of language. They used the term monetary relief, that the sanctions motions reflected the request for monetary relief. And I believe you heard appellate use those terms today. Well, the plain language of the statute doesn't use monetary relief. It says legal, equitable, declaratory relief, terms of art. And it's not just any time you ask for money, you're bringing a new claim. That is a distortion of the meaning of the word claim. We can all look it up in Black's Law Dictionary. Same thing with legal relief. We all know what declaratory relief is, equitable relief. Legal relief is monetary damages tethered to a claim. Sanctions aren't that, unless they are authorized by statute as part of a fee-shifting device. But that's distinguishable from what we did. We used the rules of civil procedure to ask the court to punish for bad conduct in the litigation, that we feel like the whole exercise was to delay, stall, have an excuse not to give us any discovery.
May
Let me
I ask
ask
another?
a-
Oh, I'm sorry.
No, you go ahead.
So if, and I noticed you were asking for the attorney's fees that your client expended in responding to the special appearance as, sort of a remedy for what you claim to be sort of a frivolous or bad faith pleading. If you had asked for, or the court had awarded, it had granted your request for sanctions, and the court had not only awarded the $18,480 in attorney's fees that you requested, but it also, in addition, tacked on, some sort of, punitive, fees, would that have changed this into something seeking damages that would then subject it to the TCPA?
I don't believe so, Your Honor, because unless it was tethered to a cause of action, a claim, that we said the common law fraud and here are our damages, because the court decides to exercise its inherent authority to sanction, and as long as it's not abusing its discretion, it can come up with whatever figure or no figure at all, or it can enjoin the parties to stop misbehaving. There are all kinds of things the court could have done. We simply offered a suggestion, but we also adduced evidence to show why it was reasonable and necessary. You'll look at some of the cases where there was a request for attorney's fees and they got slapped down because they didn't try to prove them up. So if you're going to make that request, but it's not it doesn't transmogrify a sanction into a claim, a legal claim, like breach of contract, fraud, etc.
You were talking about the Beaumont Court and then the Austin Court that picked up on the language in the Beaumont Court. But following the opinion of the Beaumont Court, do you think all motions for sanctions per se do not constitute a legal action, or just those brought under Rule 13? I mean, we just have a Rule 13 issue in front of us. But would it be the same for anything that is a motion for sanctions, or do we look at this just under Rule 13, motion for sanctions, or is there a difference?
Your Honor, there are certainly cases where, in addition to requesting sanctions, there have been counterclaims that are actual claims. And then what you have is a situation where the TCPA cannot be directed at one thing but another. And I think what is interesting in the Pate decision is that the Third Court of Appeals felt that the Thiessen language was maybe too broad to say all motions for sanctions are free and clear of TCPA litigation. But certainly, if we look at the TCPA itself, I mean, it tells us, and I made a point of turning it into Exhibit 1 so I'd have it, that this is in the construction section, which is section 27.011. This chapter does not abrogate or lessen any other defense, remedy, immunity, or privilege available under other constitutional, statutory, case, or common law or rule provisions. The TCPA itself is saying, don't mess with the Texas Rules of Civil Procedure. They still apply. We're not undermining that. So certainly a Rule 13 request for sanctions should be plainly now excluded with the amendments. They had the audacity to argue to this court in their opening brief that the amendments didn't narrow but broadened the application of the TCPA by codifying the decision in Hawkhorst. There's no evidence to support that. And in fact, what you see if you survey the case law is virtually all of the courts of appeals are following this court in Paulson. Paulson is still good law, and the idea that any use of the TCPA that perpetuates litigation by allowing you to just attack serially pleadings is an abuse. It is an absurd result based on the underlying purpose of the TCPA. That is still good law. It's still being cited by many courts, but you have this problematic thing that arose in the Third Court of Appeals, and they're now trying to tweak it, I think. And there's now been a petition for discretionary review on this Pate case, but it's distinguishable from ours because it makes a point in here in saying we're not talking about Rule 13 sanctions. So that debate that's still raging about what to do with Hawkhorst and kind of the tensions it created should not affect Your Honor's ability to affirm in this case, because the Third Court, which created this problem that then got exploited by clever lawyers in the Fourth Court of Appeals in 2 cases, that's it. Everybody else says Paulson is what makes sense to us. So Your Honors can affirm with confidence on this question of Rule 13 sanctions are not susceptible to the TCPA motion, especially in light of the amendment. But if you don't even want to go there, look at the evidence we adduced to prove sanctions were warranted. We didn't have to win. We just had to make a prima facie showing, and the Third Court itself has taken this approach in that Clear Diamond case.
So, and the only other sort of thing kind of hanging out there that I would like to get the appellee's response to is the Bibby case from this court.
Yes. Well, Your Honor, our position is there is nothing about in that decision that adopts KB Holmes' reasoning, rationale, or even holding. It's simply a see also cite in showing other things can be legal actions. Now, might it have been an unfortunate citation? Yes, but there's nothing that in Bibby where it wasn't about sanctions. Bibby was a feud about guardianship of an adult son. 2 parents, one bringing action to remove one of the parents that led to a TCPA motion. And this court quite clearly said a litigation to remove somebody's parental rights as a guardian is clearly a legal action. You're bringing litigation to affect the rights of somebody. Quite distinguishable from the issue of whether or not Rule 13 sanctions create a claim, which they don't. No right to legal relief. So that citation to KB Holmes unfortunate, but it's just saying, here's an example of a case where they found a legal action. But I think if you go look at the decision, you'll see they misquote the statute. They use this phrase, monetary relief, which is much broader than legal relief, and it is also before the amendments, I believe. I'm not certain about that. But it doesn't address this whole issue of what is a claim, except by citing very loosely the idea that if you're getting money, that's a claim. And that's not the definition. It's also not the language in the statute.
Good. No further questions. Thank you very much.
Thank you, Your Honor.
Still good with the bottom?
Oh, yes.
We're not through.
So I have some questions for you. So what if, in the motion for sanctions, they requested that the attorneys be sentenced to 10 hours of CLE instead of asking for attorney's fees? Would that be a claim for relief made by the movement? Or say that the $13,000 be awarded to a charity and not given to the movement? Would that be a claim for relief?
I think it still could be. And that goes back to Montelongo. So Montelongo looked at what constitutes a claim for relief, and a claim for relief, not just a original petition, but it can also be the addition of facts, right? Are you asking the court to look at facts that are not already before the court? So to the extent, in our case, that the request was made to the court to say that somebody perjured themselves, that's asking for a determination of facts that are not already before the court.
Well, that's just going against the motion. That's just arguing against the motion. The question, the narrow question we have here is a motion for sanctions. Now, sanction means punishment, right? Is that necessarily a claim for relief? Does it necessarily mean a benefit in yours to the moving party?
I don't think all motions for sanctions would fall under the definition of a legal action. I believe motions for sanctions that seek relief do. And so monetary relief is one of the ways that a special appearance doesn't have any fee shifting provision in it. So requesting monetary relief beyond what you'd be able to receive for just responding to a motion, I believe, does add a new claim.
So in order to determine whether a motion for sanctions is subject to the TCPA, you have to look at the prayer for relief, and that will determine. What if it asks for fee shifting, attorney's fees, and a sentence to, with all due respect to CLE speakers across the state, a sentence to 10 hours of CLE? What if it asks for both? How would we resolve that?
I think if it involves a new claim, right, to the extent that it involves a new claim, it puts new facts before the court that weren't previously before the court, then I think it constitutes, under Montelongo, it will constitute a new claim.
But if it's just, see, what's bothering me here is that the Rule 13, under the language, is a request for an appropriate sanction, which is a punishment. It's technically not requesting, it's not relief for the moving party. It's a punishment of the transgressing party that may take the form of fee shifting. It may take the form to CLE. It may take the form of making a donation to, some legal clinic or something. But at core, it is a request for punishment, not a claim for relief.
I would say that a motion for sanctions can be punitive in nature, but it is also can be compensatory in nature to the extent that it asks for monetary relief.
So sometimes it is subject to TCPA, and sometimes it's not. What if you have a hybrid one?
I'm
And-
embarrassed. We did cite a case in our brief, and I am embarrassed that I do not have that on the tip of my tongue right now. But motions for sanctions can take various forms. They can be punitive in nature. They can be equitable in nature. They can be compensatory in nature. So, you know, again, there's this danger of just painting a broad brush and grouping all motion for sanctions into the same category. And, you know, quite honestly, I think that may have been the reason that the legislature didn't address it. I mean, this dispute was going on in the courts before the legislature amended the act. But if the legislature just categorically said motions for sanctions were or were not, well, then we'd see we'd see what the plea, if motions for sanctions were excluded from the definition of a legal action, then the claims would just take another form, right? They'd be brought as a counterclaim or something else. And I think what the legislature was trying to do was to prevent this kind of creative pleading, so that the courts could focus on what the filing was actually doing instead of what it's titled. I understand that I'm out of time.
Any other questions?
No.
You want to take a minute to conclude, since I took all your time on the question?
Oh, how do I use that? Just very briefly, the legislature had the opportunity to. The legislature did amend the act, and it gave us the exact same definition of a legal action, and it did not exclude a motion for sanctions. And we believe that was intentional, based on what was before it. And, you know, KB Holmes has been dragged through the mud, but it is the only case who did a deep dive into the plain language interpretation of the act. And there's no reason for not applying a plain language interpretation to the act at this point. No court has found that the TCPA, the definition of a legal action, is ambiguous. And after the 2019 amendments, this thought that it can be abused is gone. The legislature remedied that, it tightened it up, and I think that the courts in Bibby struck on that. The legislature tightened up the definition or tightened up the application of a TCPA so that it can no longer be abused. So why are we engaging in these rules of statutory construction to further narrow the definition of the act?
Well, the flip side is that they didn't include sanctions either. So, I mean, legal, declaratory, or equitable relief, or sanction of the other party, they could have included, but they didn't.
And I believe that that is in line with the legislature's stated instruction that the act is to be construed broadly to effectuate its purpose. Thank you.
Okay. Thank you very much. Because Connect LLC versus Tran Dang is now submitted, and the first court is now adjourned.
All right.